Ruth Bader Ginsburg passed away on September 18, 2020, at the age of 87 after a long and courageous battle against cancer. The notorious RBG spent more than 27 years serving as a justice on the U.S. Supreme Court and leaves a distinguished legacy for this country. In this video, I discuss what I believe to be her top 7 Supreme Court decisions and dissents. Welcome. My name is David Jolly, and today I discuss what I believe are the top 7 decisions by Justice Ruth Bader Ginsburg during her tenure on the United States Supreme Court. In compiling these cases, I read many opinion pieces from those who compiled similar lists. These articles were from common newspapers all the way to legal scholars. What I believe quickly became apparent was that there is a general consensus for the top 3 or 4, but after that, opinions are varied. I had planned initially a top 5, but I couldn't decide between numbers 5 through 7, so I settled on 7. All right, let's get into it and start with Justice Ginsburg's most famous decisions and dissents. Gonzalez versus Carhart is a 2007 case and a landmark decision of the U.S. Supreme Court that upheld the Partial Birth Abortion Ban Act of 2003, which was a law passed by Congress outlawing a form of late-term abortion. The majority ruled that the law was not an undue burden on abortion rights. In her dissent, RBG wrote, "The act and the court's defense of it cannot be understood as anything other than an effort to chip away at a right declared again and again by this court, and with increasing comprehension of its centrality to women's lives." Shelby County versus Holder was a case regarding the constitutionality of 2 provisions of the Voting Rights Act, or VRA, of 1965. Section 5 requires certain states and local governments to obtain federal preclearance before implementing any changes to their voting laws or practices. Section 4B contains the coverage formula that determines which jurisdictions are subjected to preclearance based on their histories of discrimination in voting. The court ruled by a 5-4 vote that Section 4B is unconstitutional because the coverage formula is based on data over 40 years old, making it no longer responsive to current needs and therefore an impermissible burden on the constitutional principles of federalism and equal sovereignty of the states. In one of her most notable dissents, Justice Ginsburg wrote that this decision terminates the remedy that proved to be the best suited to block voting discrimination. She continued, "The sad irony of today's decision lies in its utter failure to grasp why the VRA has proven effective. Throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet." In the 2000 presidential election, former President George W. Bush took a lead over former Vice President Al Gore by less than 0.5% in Florida. Such a close margin meant the state law required a recount. Gore filed a complaint for a hand count in the county circuit court as concerns over ballot design flaws, the infamous hanging chads, loomed large over the election. The Florida Supreme Court ordered a hand vote recount of the ballots. The U.S. Supreme Court heard the case and the majority ruled that no better method of counting votes could be established within the necessary timetable. Justice Ginsburg wrote that the conclusion that a constitutionally adequate recount is impractical is a prophecy the court's own judgment will not allow to be tested. Such an untested prophecy should not decide the presidency of the United States. Instead of concluding her opinion with the normal and well-practiced phrase, "I respectfully dissent," Justice Ginsburg concluded her written opposition with just 2 words, "I dissent." Stafford Unified School District versus Reading was a case in which the Supreme Court held that a strip search of a middle school student by school officials violated the Fourth Amendment to the U.S. Constitution, which prohibits unreasonable searches and seizures. In this particular case, school officials at Stafford searched a 13-year-old girl's backpack and underwear after the receipt of a report that she was distributing drugs to fellow students. The Supreme Court made an 8-1 decision that the search did violate the 13-year-old's Fourth Amendment rights, which prohibits people from unreasonable searches and seizures by the government. RBG, the only female Supreme Court justice at the time, voted with the majority. In a 2009 interview, she expressed frustration with some of her colleagues for being unable to understand the young lady's position. She stated, "They have never been a 13-year-old girl. It's a very sensitive age for a girl. I didn't think that my colleagues, some of them, quite understood." Friends of the Earth versus Laidlaw Environmental Services is a 2000 case which involved the environmental organization Friends of the Earth, which filed a lawsuit against Laidlaw Environmental Services. Laidlaw's wastewater treatment plant had apparently failed to abide by the limit on mercury discharges into a local river on over 400 occasions in a period of less than 10 years. Justice Ginsburg delivered the 7-1 decision and wrote, "Illegal discharges of pollutants into a river would cause nearby residents to curtail the recreational use of that waterway and would subject them to other economic and aesthetic harms." The second issue heard in this case was the issue of whether the case should be dismissed as moot because, according to the defendant, they had ceased polluting. The court rejected the dismissal claim, and Justice Ginsburg stated the civil penalties were appropriate to deter future violations. She continued, "A would-be polluter may or may not be dissuaded by the existence of a remedy on the books, but a defendant once hit in its pocketbook would surely think twice before polluting again." Olmsted versus LC is a 1999 United States Supreme Court case regarding discrimination against people with mental disabilities. The respondents were women with mental illnesses who were institutionalized in the hospital even after medical professionals stated they would be able to continue their treatment in a community-based program. Justice Ginsburg delivered the majority opinion that held that the 1990 Americans with Disabilities Act demands that states are required to place persons with mental disabilities in community settings rather than in institutions. When treatment professionals deem it appropriate, the individual does not oppose the transfer and the state can reasonably accommodate. This decision marked an historic step for disability rights. The United States versus Virginia is a landmark case where the U.S. Supreme Court struck down the long-standing male-only admission policy of the Virginia Military Institution. In a 7-1 ruling, the court held that the Virginia Military Institute's male-only admissions policy violated the Equal Protection Clause of the 14th Amendment. RBG wrote the majority opinion in this 1996 case and pointed out that today's skeptical scrutiny of official action denying rights or opportunities based on sex responds to volumes of history. As a plurality of this court acknowledged a generation ago, our nation has had a long and unfortunate history of sex discrimination. Justice Ginsburg described as presumptively invalid a law or official policy that denies to women, simply because they are women, equal opportunity to aspire, achieve, participate in, and contribute to society based upon what they can do. Looking through her greatest decisions and dissents, Justice Ginsburg's legacy will be long-lived with her advocacy for the disabled, the environment, voters' rights, the Fourth Amendment, gender and race equality, and of course, she was a trailblazer for equal rights for women. Justice Ruth Bader Ginsburg may have stood only 5'1" tall, but she was a giant in the legal community and in the history of this country.